Good afternoon, Rimsky. Thank you very much for taking the time for this interview.
Well, most welcome. Good afternoon.
Thank you. Thank you. You were recently appointed the Hong Kong HKIAC co-chair alongside David Rivkin, Tebubaz and Plimpton in New York. And the purpose of this interview is to talk to you a little bit about HKIAC, about Hong Kong, about arbitration, and for some of our viewers to get to know you better.
Okay, good.
Yeah, so before we get started, what I wanted to do is give just a brief overview of your very illustrious legal career. I won't go into too many details because that will eat up a lot of time. But you were born and raised in Hong Kong. You are a true Hong Konger. You studied law in Hong Kong, both undergraduate and postgraduate. And then you joined the bar.
Yep.
And you joined the bar 33 years ago. And
yep, more or less.
You joined Temple Chambers in 1995, and then in 2003 you were appointed senior counsel. So
correct.
Yes. So you've been practicing as senior counsel for 17 years.
Yes, time flies.
Yes. And then for 6 years, between 2006 and 2012, you were a recorder in the High Court of First Instance of Hong Kong. So as well as appearing as counsel, you have also done your part as a part-time judge, let's say.
Yes, correct.
Mm-hmm. And then in 2012 until 2018, you served as the Secretary for Justice for the Hong Kong SAR government. So you were the Secretary for Justice just before Teresa Cheng SC, who's currently serving in that role.
Correct.
And then I think it's accurate to say that after your term as SJ, you have been focused increasingly and very much so on international arbitration, both arbitration seated in Hong Kong as well as elsewhere. And just a few weeks ago, in fact, 30 days ago, you were appointed as HKIAC co-chair.
Which is my great honor and privilege, if I may put it that way.
And it's our great honor and our great privilege and pleasure as well. So what I wanted to talk to you about was, first of all, your early experiences in arbitration. Do you remember your first ever arbitration, whether that was domestic or international?
It was a domestic arbitration. It concerned the renovation of a building in Hong Kong. Uh-huh. And it was more to do with very technical construction issues as well as legal issues in the area of construction law. I don't profess to be a construction lawyer, but my first arbitration happens to have something to do with the construction law of Hong Kong.
Yeah, that's not surprising given the amount of construction arbitration that there is in Hong Kong, and the fact that it's been such a traditionally busy construction arbitration market in Hong Kong. In fact, that's partly what HKIAC was born from, was construction.
Indeed.
In Hong Kong. Mm.
Indeed.
Yeah. And have you continued to do quite a lot of construction arbitration, or in the cases that you're sitting in nowadays, what kinds of cases are you seeing mainly?
Well, I don't do that much of construction cases. In fact, in the past decade or so, I have not touched on any real or hardcore construction disputes at all. My focus have all along been commercial disputes. So whether in terms of court litigation or arbitration or mediation, my focus have all along been primarily commercial disputes.
Mm-hmm. And you come from such a long background steeped in Hong Kong law and steeped in litigation, both as a barrister, but also, as I mentioned before, acting as a judge. And now you've moved much more into the role of sitting as an arbitrator. What do you see from a Hong Kong perspective as the main differences in your experience in litigation and then in arbitration in Hong Kong?
I think I would say the two main differences are flexibility and confidentiality. I think flexibility in terms of the procedure and in the way in which the disputes can be resolved is one of the main features of arbitration. Although parties are of course bound by the rules that they have chosen, but then as you appreciate, the tribunal has much flexibility in terms of dealing with procedural matters as well as in other logistical issues. And then in the context of court litigation, however, I think parties and also the judges are bound by the rules of the court. Now, of course, after the civil justice reform in Hong Kong, the court is more focused on questions of case management. But relatively speaking, I think arbitration is still far more flexible. The second area which I think distinguish arbitration sharply from court litigation is confidentiality. And as I understand, I think this is one of the main reasons why many people prefer to have arbitration rather than court litigations. Not just cases which involve trade secrets or confidential information, but generally speaking, I think for good reasons, commercial men generally do not want to have their disputes being reported in the newspapers, which is perfectly understandable. So I think these two are the main areas which make arbitration very different from court litigation.
Mm-hmm. And now that you're sitting much more as an arbitrator after a very long career appearing as counsel, I think one thing is true is that for counsel appearing before arbitrators who have served as counsel themselves, there is a recognition in what is happening in the process. As an arbitrator looking on after a very long career as counsel, what are some of the things you appreciate most about counsel appearing before you? And what have become, if I may say, any of your pet peeves with counsel appearing before you?
I think from the perspective of the tribunal, the most important thing I believe would be the presentations of the case in such a way which would assist the tribunal in resolving the disputes effectively and also fairly. I think nowadays, whether in arbitrations or in court litigations, I think judges and arbitral tribunals do not expect advocates to be, say, ferocious or overly fierce, particularly in dealing with witnesses. I think what we're after is efficient, effective, and fair presentations of the party's case. And I think this is even more important when it comes to what the tribunal would expect from the advocate. And I think maybe among others, a very direct and effective answering of the tribunal's question is something which I think every tribunal would welcome, rather than beating around the bushes or giving answers which do not really answer the question. Although I can understand, having been advocate myself, I can understand sometimes why counsel do that.
Absolutely.
Yes.
But of course, you're right. At the end of the day, the tribunal must deliver an award, so it must have the answers to the questions and the issues that it needs to address. There's no way around it. So you were the Secretary for Justice for 6 years in Hong Kong, and over that time, there were some quite important legislative changes that impacted significantly on arbitration, and Hong Kong is a dispute resolution centre. And of course, Hong Kong was the first major Asian jurisdiction to adopt the Ancitral Model Law 2006 back in 2011. So over time, the legislation has always adapted to new changes and developments. And I wondered if we could talk a little bit about some of the developments that happened under your tenure as SJ. They included changes to the emergency arbitrator legislation in Hong Kong, third-party funding, which was a very big development for Hong Kong, and then also changes in respect of clarifying the position around intellectual property rights and arbitration. And I also know that you were very much supportive of the amendments with respect to the apology legislation, which came into effect during your term, which also has its place in the dispute resolution landscape. Thinking of all of those varied achievements, if you have any comments on them, but also are there any other areas that you think or you would like to see Hong Kong move in the direction of, or further developments in the legislation?
Well, my personal view is that in promoting Hong Kong as an international arbitration center, I think one has to look at the legal infrastructure, because arbitration is not conducted in a vacuum. And one of the main reasons how parties to a dispute would decide on which jurisdiction to become the seat of arbitration would be the legal system of the supervisory jurisdictions. And looking at it from this angle, I took the view when I was the Secretary for Justice that it would be important to ensure Hong Kong's legal infrastructure and legal system, put it more generally, to be keeping in place with international development, as well as to see whether there are areas that we need to meet the needs of the end users, namely the international community, including in particular the international commercial community, so that they will feel more comfortable in coming over to Hong Kong and choose Hong Kong as the seat of arbitration. And it is from this angle that one of the tasks that we have been focusing on is to look at the legislation, in which case in Hong Kong is the Arbitration Ordinance. And it is from this angle that some of the reforms were put forward, such as the one involving intellectual property, which we introduced legislation to clarify that the disputes concerning intellectual property can be subject matter of arbitration and would not affect the aspect of enforceability, because in the past, in common law, both in Hong Kong as well as in some other jurisdiction, we can see that there was some uncertainty in the past. So we want to introduce legislations to clarify that. And we believe that is important because intellectual property disputes is one of the growing area, not just in Hong Kong, but in the Asia Pacific region. And this is wholly understandable. So this is one of the reasons why we introduced that. And third-party funding, which is another aspect that you mentioned, we also push forward that legislative reform, also from the perspective of enhancing our legal infrastructure. But in that regard, we also take into account the perspective of access to justice, because we want to make sure that people who have a meritorious case, whether by way of a claims or defense, will have a chance to address them through arbitration. And also, even if they are financially sufficient to deal with arbitrations on their own, we believe the provisions of third-party funding can allow them to, in a way, regulate and plan their financial resources in more effective manner. So I think all in all those legislative reforms that we introduce are with the same and single aim, namely to enhance our legal infrastructure so that people can find the arbitration regime in Hong Kong is user-friendly.
Absolutely. And here at the HKIAC, we've started to see arbitrations being funded by third-party funders since it became lawful early last year, and with the issuance of the Code of Conduct. And we understand that there are more in the pipeline. So we see come to fruition what you say, the legal framework making some of these options, which are commercially and in terms of access to justice, very important, coming to fruition. Another project that is very much coming to fruition, which was born during your tenure, was the creation of the Legal Hub, which is home of various dispute resolution and international bodies in Hong Kong. And I know that there are quite a few organizations moving into their offices now already and in coming weeks. So that's exciting to see as well.
Yes, very much so.
Yeah. HKIC, of course, will stay here at its current premises, and we have some interesting developments with respect to our premises that we'll come on to a bit later. But the other development that I wanted to talk about and wanted to talk to you about today was the interim measures arrangement between the Supreme People's Court of Mainland China, of the People's Republic of China, and the Hong Kong Department of Justice, that was drafted last year and came into effect in October. And what that provides for is, what the significant changes under that arrangement is that parties to arbitrations seated in Hong Kong, administered by a qualified institution, of which HKIAC is one, may apply to mainland Chinese courts for interim relief for the preservation of assets, conduct, or evidence. And that was not possible before. And that is unique to Hong Kong, in that it only applies where the seat is in Hong Kong. And I wanted to get your views on that development in terms of what does that mean for Hong Kong's future as a dispute resolution venue? What does it mean for foreign parties contracting with mainland Chinese parties? And what does it mean for mainland Chinese parties?
I think on the whole, it's a very significant development in terms of arbitration in Hong Kong, as well as from the perspective of mainland China. Well, first of all, interim measures is an important topic in international arbitration, irrespective of which jurisdictions you are talking about. Say in court litigations, people would rush for injunctions, whether Moreover injunctions or sometimes anton-pillar orders, if there are urgent needs of doing so. So in order to be comparable and to be equally effective in protecting parties' rights in the context of arbitration, interim measures are equally important. And therefore, as I just mentioned, in international cases, interim measures have long been a popular topic. But then in the past, because of the differences between the arbitration law in Hong Kong and that in mainland China, we experienced difficulties in the past when we want to, in a way, deal with the questions of interim measures. But fortunately, after much discussions, the arrangement that you mentioned has been put in place. I think this is important from various perspectives. First of all, from the perspective of Hong Kong, I think we see many cases of arbitration in Hong Kong involving mainland parties. And I think this is this can be seen from the statistics kept by the HKIAC. And I would expect, in fact, the figures to go up in the near and medium future, if not also in the long-term future of Hong Kong. So it's important to, in a way, fill up that gap in the context of arbitrations between Hong Kong and mainland China, or in the context of arbitrations involving mainland parties. So that is very important from the Hong Kong perspective. And conversely, I think it's equally important if one to look at it from the perspective of mainland parties stationed in mainland China, because sometimes it is they who want to get interim measures in Hong Kong or against Hong Kong parties. And therefore, the arrangement that you mentioned would be important no matter whether you look at it from Hong Kong or whether you look at it from mainland China or mainland parties. And from a more macro perspective, I think it would enhance Hong Kong's status as an international arbitration center, because not every arbitral institutions can do that, at least for the time being. And I think that would be one of the strength and advantage of the HKIAC over other arbitration institutions in the region. And I can well understand why people would choose, and I think rightly so, the HKIAC for that reason. Yeah. Looking at it from a slightly different angle, but also a macro angle, is that you also mentioned about the Belt and Road at the earlier part of your opening. I think this is also important in the sense that because Hong Kong has all along been positioned to deal with disputes in projects which are in the course of the implementation of the Belt and Road Initiative. This has been the policy of the central government, and we believe this is a very important policy and correct direction, because Hong Kong has the experience to deal with international disputes. And also in the context of the Belt and Road, there are so many jurisdictions with so different jurisdictions. So arbitration is one of the best way to resolve disputes. And therefore, therefore, for those parties involved in the Belt and Road disputes, I think they would also see the advantage of using Hong Kong as the seat of arbitration, and also choosing the HKIAC as the arbitral body to deal with and handle the disputes, bearing in mind, among other factors, the interim measure arrangement that you mentioned. So on the whole, it's an important move, and I'm glad that the HKIAC is doing very well in that direction.
It's been very interesting to watch the applications that do come through under the arrangement and to see what is happening in that role. We, of course, have a role under the arrangement of confirming that an arbitration has been commenced in Hong Kong and is being administered by HKIAC. And what we've seen is a total of 24 applications under the arrangement already. And those are, for the most part, in respect of preservation orders over assets in the mainland. And the total value of assets over which the preservation orders have been sought are up to $1.3 billion US. And of the applications that we know of that have been granted, they cover $1.1 billion US worth of assets. So it's really a significant commercial advantage that is meaningful. So that's been interesting to watch. And then the other aspect of it that has been very interesting to watch is who the applicants are and who the respondents are. So we see that in 60% of the applications, the applicant is a foreign party. And then in 40%, the applicant is a mainland Chinese party. So we see also mainland Chinese parties benefiting from this arrangement with respect to assets on the mainland. And then in respect of the respondents, we see it's 50-50 split. 50% are mainland Chinese owned assets and 50% are foreign owned assets. So really it's about the owner, the assets, who owns the assets. And that's been very interesting to trace. And we trace that, as you know, we trace that very closely.
Well, I think it's perfectly correct for you to mention all those very interesting and important features, if I may say. If I may just add one observation. So I think from what I have heard and from what I have observed, I think the mainland courts have been very efficient
Mm.
in handling interim measures applications coming from the HKIAC. I think it's very encouraging. And in addition to what I've just mentioned and also what you have explained, perhaps I can do a little bit of commercial here. I think that that would be a very good reasons why in future in-house and other people involved in arbitration should take into account when they are drafting arbitration calls. And this is one good reasons why they should go for HKIAC.
Yeah, yeah. I think that is the conclusion. Yeah, it's such a significant commercial advantage. So yeah, commercial appreciated.
Thank you.
Yeah. One thing you mentioned Belt and Road disputes, and of course, that's been now being implemented since 2013. So we're 7 years into the initiative, and we're also at quite a tumultuous time for many economies with COVID-19. And we at HKIAC have seen the Belt and Road disputes start to come through, and they are in various forms. And we often see a connection with Southeast Asian jurisdictions and companies in the cases that we're seeing. But in terms of, I wanted to talk a little bit about the impact of COVID-19 on arbitration and on Hong Kong. What we've seen, as you know, is that there's been a real spike in the need for virtual hearings, because when it became apparent to parties and tribunals at the outbreak of the pandemic that this was not going to end quickly and it was not going to be confined to a few countries, that really there had to be a way of allowing proceedings to go forward even if people were stuck in their home jurisdictions and couldn't travel. So at HKIAC, we've had about 60% of the hearings that we've had since the beginning of the year have been virtual, either partially or fully. And for the hearings that we have already booked to the end of the year, we have about 50% that involve virtual hearings in some way, shape or form. And I know that you yourself you have sat in virtual hearings, and quite a number actually. And in fact, you've sat in one of the most complex arrangements, if I can say that, as virtual hearings go, in respect of a merits hearing that lasted for 10 days, involved 11 fact and expert witnesses from 9 jurisdictions, multiple time zones, involved a lot of cross-examination, and involved counsel here in Hong Kong as well as in London, and if I'm not mistaken, also in Korea. But you sat in that case as a tribunal member. I think there were also a lot of documents involved. Can you talk to us a little bit about your experience in the virtual hearings that you've had, the more simple, the more complex, and what you think this means for the future of international arbitration?
I think the impact of COVID-19 is going to last even after it's going to diminish, which I hope would come very soon, of course. As you rightly point out, one of the aspects is on the impact of remote hearing or virtual hearing. And in fact, this is one area which illustrates that international arbitration is really very flexible and can be reactive to changes very quickly. Because I think looking at how the HKIAC has performed, and indeed other arbitral institutions around the world has performed, I think it goes to show that as changes come about, the HKIAC can react very quickly so as to facilitate the continuation of arbitral proceedings despite the outbreak of COVID-19. The use of virtual hearing via video conferencing facilities is one of the examples. And I think you will know better than I do that the HKIAC has put in more resources, including an additional staff and more equipment to ensure that parties who are in need of assistance for remote hearing would be provided with quality service. The case that you mentioned is a very interesting case, and I was very lucky to have a chance to be involved. And my personal experience is that despite the involvement of people whether in terms of witnesses or in terms of counsel from different jurisdictions, Hong Kong, London, and some other cities in the United States. And despite the time differences, we managed quite well to have the hearing conducted via video conferencing facilities. And I have to confess that as a barristers in Hong Kong, we normally are very traditional, and we normally would prefer to handle witnesses, particularly cross-examination of witnesses, in person, because we always believe that it would be important to see the immediate reaction. It would also be important to see the immediate reaction of the tribunal, so as to decide what next questions is to be asked and how the questions should be asked. And therefore, in the past, I think advocates would normally prefer to have hearing in person. And if there is a choice, very often people would say, look, I prefer hearing in person rather than virtual hearing. But I think the culture is changing. I think more and more people, including advocates, are far more receptive now than before to have virtual hearing, because I think probably partly due to change of circumstances and partly due to the advance of technology. I think technology now is better than in the past. So we can have more sort of, in a way, immediate and instantaneous responses from the witness. And therefore, I think this is going to change the way international arbitration is going to be conducted in the future. I dare say, I think there would be more and more people going for virtual hearing even after COVID-19 is properly handled. And I think that would also, in a way, bring about other consequential advantages for using virtual hearing, because if you don't need to fly the witnesses from overseas to Hong Kong, you save a lot in terms of air tickets and also hotel accommodations. And that will be, in a way, one way to control the cost of international arbitration. And therefore, I think in the long run, of course, no one would like to see the outbreak of COVID-19, but in terms of international arbitration, one of the impact is in a way positive, in the sense that it changed the culture and people are more receptive to virtual hearing, and I would say rightly so.
We're seeing a spike in cases in Hong Kong at the moment, and the government's taken some swift measures to address that. I want to talk a little bit more about Hong Kong, because it's not just COVID-19 that has Hong Kong in the news recently and over the past year. But of course, we had the civil unrest last year between June and December that started from the extradition bill. And then COVID-19 came through at the beginning of this year. And we've just seen the promulgation of the National Security Law by the Standing Committee of the National People's Congress. So that's just been newly passed. And I wanted to take this time with you because, of course, you have such a unique vantage point, having been with the government in your former position. And now, from that point of view, and as a jurist, what is your take on how these new developments in Hong Kong will affect Hong Kong, first as an international financial centre, and secondly as an international dispute resolution centre?
Well, you are very correct in pointing out that in the past year, Hong Kong has had a lot to deal with. First of all, the demonstrations, the protests, and then the COVID-19, and most recently the enactment of the national security legislation. And I think I have to admit that due to these incidents, the reports that we have seen in the local as well as overseas medias have not been particularly good, at least from time to time. But in the context of arbitration or dispute resolution, I would venture to say, and I believe this is definitely correct, that whatever has happened in the past year, including those 3 areas that I just mentioned, I don't think it affects Hong Kong's position as an international arbitration center at all. The reason I think is very clear, and that is the nature of arbitration is quite unique, because, say, in terms of the most important aspect, that is the decision that the party is going to face at the end of the arbitration, is made by the tribunal. And whatever people said about what is happening in Hong Kong recently, the fact is, and the fact remains, that the arbitral tribunal is chosen by the parties. So the parties have the say, have the final say as to whoever is to be the members of the tribunal who would make the decision. And therefore, there cannot be any questions of independence, there cannot be any questions of neutrality, there cannot be any questions of partiality. That, I think, is one of the most important points. And I would say equally important is, no matter what has been said about Hong Kong in the past year or so, I personally take the view that the judiciary in Hong Kong remains truly independent. I haven't seen any sign which can throw doubt on the independence and the professionalism of the Hong Kong judiciary. And of course, looking at it from the perspective of arbitration, it's also important to stress, as is the fact, that the Hong Kong judiciary has all along been very arbitration friendly. They have been very pro-arbitration, whether in terms of staying staying civil actions for arbitration, or whether in the context of enforcement of arbitrations. I think we have seen this from the reports made by, or from the judgments which are reported by the judiciary. I don't think I need to give any specific examples, but people in the arbitration circle would definitely agree that the judges and the courts in Hong Kong have been giving very good and effective decisions on arbitrations. And lastly, I think, if I may add the point which perhaps have been repeated from time to time, but I think it's still important to stress, is that we have a very unique system, and that is in our Court of Final Appeal, which is the final court in Hong Kong. We have the presence of overseas judges, and they are very eminent overseas judges. Examples include, say, Lord David Neuberger. In the past, we have Sir Anthony Masons. We also have Lord Walker. All these are very well-known judges, whether from the UK and some from Australia, and we also have overseas judges from New Zealand and also Canada. And some of the leading arbitration cases are decided with their presence and involvement. So I don't think anyone can doubt their independence or expertise. So And I don't think any other jurisdictions has that advantage. Therefore, I think I would say no matter what has happened in Hong Kong in the past year, I don't think it affects Hong Kong's role as an international arbitration or dispute resolution center. And I'm quite confident that things would remain that way in the years to come.
Yeah. Well, thank you, Rimsky, for your time. I think our time is up, and it's good to end on that encouraging note from you. So maybe one last question. You've been in the role now for 30 days as HKIAC co-chair. How do you find it so far?
I wish I have more time to do what I want to do, but at the same time, I want to say something, and I want to say this not because you are interviewing me, but I think I really want to express my gratitude to you and your very competent team of colleagues in the HKIAC, which I dare say, without you and the other colleagues, I don't think we can run the HKIAC as smoothly as we now see. And I would also venture to say, without you and your team, I think council members will have a far more difficult life. So thank you very much. But I think I would look forward to have more time to talk to David as well as other council members and to map out the blueprint for the HKIAC in the coming year. And I think we need to definitely get down to business so as to consolidate the positions of the HKIAC. So allow me to say thank you to you and all the other colleagues.
Well, thank you very much, Rimsky. That's very kind. And we very much look forward to working with you and David over the coming 3 years. Thank you very much. Thank you.
Thank you. Have a good day.
You too. Thank you.